Hello, everybody. This is Rob Walker. I'm of Counsel with Wiley, Rein's Election Law and Government Ethics Practice Group. Welcome to another episode of our Political Law podcast. I wanted to talk today, or at least give a brief sketch and outline of how Congress, how the House and the Senate may enforce subpoenas. If they issue a subpoena for documents and records to an individual, an organization, and if the recipient of that subpoena refuses to respond or to cooperate fully. It's a subject, a topic that is on a lot of people's minds these days, particularly in connection, although not only in connection with the ongoing tug of war, to put it gently, between the House and the White House with respect to information requested or subpoenaed from the administration by the House. For example, just yesterday, Congressman Jerry Connolly appeared on CNN and with respect to subpoena enforcement on subpoenas sent to the administration, whether the White House or other agencies or departments of the administration, Congressman Connolly said, if a subpoena is issued and you're told you must testify, we will back that up. And he went on to say, we will use any and all power in our command to make sure it's backed up, whether that's a contempt citation, whether that's going to court and getting that citation enforced, whether it's fines, whether it's possible incarceration. And he concluded on this subject, we will go to the max to enforce the constitutional role of the legislative branch of government. So just how does Congress, either the House or the Senate, go about enforcing a subpoena that it may issue? Well, first of all, it's important to know there are three different ways, essentially, basically, through which the House and the Senate can and may seek to enforce subpoenas that they issue. The first method is called the inherent contempt authority or power of the Congress. And really, since essentially the beginning of the American Republic, the courts, the Supreme Court has found, although it's not stated in the Constitution specifically, that the contempt power is an inherent attribute of Congress's legislative authority, a necessary and inherent attribute, because the court essentially said if the Congress is going to request or subpoena information, that authority to seek the information would be meaningless if there were not authority to back up those kinds of requests or subpoenas when the information is subpoenaed. So there is inherent contempt authority and power for the House and the Senate. And one way of enforcing a subpoena, if a congressional subpoena is issued and the individual either refuses to testify or produce records or doesn't fully cooperate, one way to enforce that is through inherent contempt proceedings in the House or Senate. And in inherent contempt proceedings, the person resisting the subpoena or cooperation, once a subpoena has been issued, would be tried at the bar of the body, basically, essentially in the well of the House or the Senate. If through that trial they are found in contempt, they could be, at least theoretically, imprisoned by the House or the Senate. Where that would be is a good question. There used to be a cell, kind of perhaps better described as a room in the basement of the Capitol, not great accommodations, and I suspect alternative accommodations might be found if this mode of contempt were ever followed again. And this kind of contempt, inherent contempt, where the House and the Senate act and enforce their own subpoenas on their own, may be either punitive or coercive. That is, an individual contemnor can be punished simply for being in contempt of Congress, or they could be imprisoned coercively, that is, held and imprisoned until the individual decides to cooperate with the subpoena. Now, there's important things to note about the inherent contempt power. First of all, it hasn't been used by either the House or the Senate in almost 85 years. It is a mode of seeking contempt that, at least as it has been applied in the past, in the very distant past at this point, was very cumbersome. It required basically a trial before the full body. The rest of the business of the body, such as it is or was, would be held in suspension. There are all sorts of issues that would arise, particularly if the individual being tried and held in contempt in this manner is an official of a co-equal branch of the government, the executive branch. How is that really going to be enforced? Would there really be an arrest and someone held in Congress based on this inherent contempt power? So it clearly is and has been a disfavored approach to enforcing a congressional subpoena. Again, time-consuming. And furthermore, it appears that the ability to punish under this or to hold in contempt, to basically imprison someone until they decide to cooperate. Really, the authority would expire at the end of each Congress. So, if the proceeding is brought at the very end of a Congress, it might not be more than a few days, bad as that might be. So could this approach to contempt be revived in the current climate between at least the House in Congress and the administration? There has been talk about that. I don't know how serious there is talk about it within the Congress itself, but certainly a number of commentators have raised the issue of whether this now disfavored mode of contempt should be revived. There was an article in the Washington Monthly just a few days ago by Martin Longman saying that Congress basically needs to revise its inherent contempt power. An article entitled, "Congress Needs to Lock Up Non-Compliant Witnesses." There are analysis in March 2019 by the Congressional Research Service, which is a part of the Library of Congress and researches issues for offices of the House and the Senate, which discusses what would happen or the alternative potentially of reviving the inherent contempt power. And typically the Congressional Research Service, CRS, doesn't answer questions that have not been posed to it by a member of the House or Senate. So it appears that somebody has certainly asked that question. I'd be surprised if there has not been at least consideration of how this could be done, if it would be done. And there is a discussion through the research and otherwise of the possibility that instead of the punishment being imprisonment, maybe the inherent contempt power could be used to impose a fine. Maybe it wouldn't take a trial before the full body of the House or Senate. Maybe it could be done by a committee, at least initially, charging the individual with only part of the proceedings taking up the whole time of the whole House or Senate. So there's been discussion of how to kind of streamline inherent contempt, but so far, no indication that it's actually being considered to be used again. So that's one mode of enforcing a subpoena. The second mode through which the House or the Senate may enforce a subpoena to a non-cooperating witness is through the avenue of statutory criminal contempt. There are federal statutes, Title II of U.S. Code Sections 192 and 194, which provide for a criminal action to be brought if an individual has been found in contempt of the House or the Senate. And this avenue first requires that someone who has received a subpoena has failed to produce information or documents as required by the subpoena, or failed to appear, or perhaps they have appeared but refused to respond. In that case, before the criminal contempt statute, either House or Senate could avail themselves of this avenue to contempt. A contempt citation would have to be voted on and through first the subcommittee through which the individual had been subpoenaed, if there was a subcommittee, then the committee, a full committee, and eventually the full House and Senate would have to authorize a contempt citation. And after that contempt citation is certified either by the president of the Senate on the Senate side or the Speaker of the House on the House side, the contempt citation would be referred for enforcement to the U.S. Attorney's Office for the District of Columbia. And interestingly here, the question is, what would the U.S. Attorney's Office have to do with it? The statute says that the U.S. Attorney, the Department of Justice, have a duty to present the contempt matter to a grand jury. But in recent years, when this statutory criminal contempt approach has been followed against an administration official, quite understandably, or not surprisingly, I should say, the Justice Department has determined not to present the contempt citation to a grand jury when the individual who has been found about whom a contempt citation has been issued by Congress is in the same administration as the Department of Justice officials making this determination. And that has been the case in recent years. For example, with respect to Harriet Miers and Josh Bolten, Harriet Miers, the former White House counsel, and Josh Bolten, former White House chief of staff, their matters were referred in 2008 to the Department of Justice. As I recall, those matters were actually not litigated. There was similarly a matter in 2012 involving then Attorney General Eric Holder. This was referred to the D.C. U.S. Attorney's Office, and that office and the Department of Justice determined not to present the matter to a grand jury. And similarly, in 2014 with Lois Lerner of the IRS, that really basically followed a similar fate. So this is an avenue of enforcement of a congressional subpoena, which obviously has very serious consequences for the person regarding whom a contempt citation is issued by the House and the Senate. It could be a criminal matter punished criminally with criminal enforcement. It would be the approach here is punitive through this method. It really is not an approach. Criminal contempt enforcement is not an approach through which you can really hold leverage over an individual to get them to cooperate. So the consequences are severe. Having said that, as I've explained, it is not typically and historically an approach that really works when Congress is of one party and the administration is of another party. So there is a third avenue through which the House and the Senate can enforce subpoenas, and that is statutory civil enforcement. Now, specifically, the statutory civil enforcement avenue is at least available by specific statute only on the Senate side. There is a statute that provides that the legal counsel, the Office of Legal Counsel for the Senate, may bring a civil action in the District Court of the District of Columbia to enforce a subpoena, secure a declaratory judgment about a subpoena regarding the validity of a subpoena, or to prevent a witness's threatened refusal to comply with a subpoena. Now, I say the Office of Legal Counsel may do this. That office has to be authorized to do so first through a resolution by the full Senate. Upon passage of such a resolution, the Office of Legal Counsel, the OLC, may then be authorized to bring suit. Now, the interesting thing about this statutory civil enforcement avenue, available again only on the Senate side, is that it does not apply and may not be used to enforce subpoenas issued to executive branch officials. And so it is the preferred method in a lot of ways by the Senate to enforce subpoenas. It is more streamlined. The decision as to whether to bring the matter to court is within the authority and within the sole discretion of the Senate itself. Having said that, it is not a vehicle that could be used in connection with subpoenas to executive branch officials. That is statutory civil enforcement on the Senate side. The statute does not apply to the House. However, having said that, the House, as it has done in relatively recent years on a few occasions, may proceed on a similar path, a similar civil enforcement path, on an ad hoc basis. If the House, if a witness, if a House committee, and then eventually the full House find and pass a resolution finding that a witness has failed to respond to or to cooperate with a subpoena, and again, if the House passes a resolution, contempt resolution to that effect, it may thereby authorize the Office of the General Counsel of the House to enforce this subpoena in question in the District Court of the District of Columbia. And by doing so, the House General Counsel may seek declaratory or injunctive relief. And so this, again, although not by statute, the House essentially has found a way to undertake the same method of civil enforcement that the Senate has. And there have been a few instances in recent history where this approach has been taken by the House of Representatives. In 2008, there was a civil enforcement resolution passed and action taken, again, with respect to Harriet Mears and Joshua Bolten. And then in 2012, with regard to former Attorney General Eric Holder. The matter involving Attorney General Holder, I think at least technically is still pending, or at least it was as of the end of the last Congress. And you can see from that the resolution of these contempt issues is complex and can take a great deal of time. And that ought to be considered in reflecting on whether the contempt process is really an effective mechanism in this day and age with respect to, at least with respect to subpoenas to other government agencies and officials. The process of enforcement can certainly be drawn out a long time. And might it take so long, whichever avenue is pursued, might it take so long to resolve all the complicated legal issues involved that it really is not an effective path to take. Having said that, when the authority of Congress is ignored, Congress does have some obligation, at least I'm sure this is the thinking of folks in the House, Congress has some obligation and requirement to enforce its authority and to seek clarification of its authority in the court. So it's an interesting set of circumstances. There's an interesting history to the congressional enforcement of its subpoenas, particularly with respect to enforcement against administration officials throughout history. There are obviously related issues, constitutional issues that individual witnesses, private individuals may raise in connection with subpoena enforcement actions. They may challenge them on the basis of whether the subpoena is, first of all, the investigation in connection with which a subpoena was issued was properly authorized. That's not usually a winning challenge. Whether the subpoena issued is pertinent to that investigation, again, that's not usually a winning challenge. Doesn't take much to draft a subpoena that's deemed to be pertinent. But there may also be constitutional challenges brought in connection with the service on a witness of a subpoena, including First Amendment challenges, Fourth Amendment challenges, and Fifth Amendment challenges. So that's a basic sketch of the general ways in which the House and the Senate may seek to enforce subpoenas. And these issues are not going to go away. And in fact, they're going to become more and more prominent over the next weeks and months. Some new law is inevitably going to be developed in this area based on the challenges that are expected or even outstanding at the moment by recipients of House subpoenas. So something to keep your eye on. And as things develop, we might even talk about it again on this Wiley Rein Political Law podcast. Thanks for joining today, and talk to you next time. Bye.